Welcome today to our HR's Handling the Disciplinary Process webinar that's being facilitated by HR Recruit and Nathan Andrews from Frettens Solicitors. My name's Jo Thompson and I'm a consultant for HR Recruit. I'm joined today by Nathan, who will introduce himself shortly. Nathan will discuss things we should consider to help reduce risk for the organisation and good practice guidance to ensure a fair outcome for the employee. If you've got any burning questions during the session, then please put them into the chat box facility and we will cover them at the end. I'm now going to hand you over to Nathan, who will introduce himself and start the event. Thank you.
Thank you, Jo. Hi, everyone. Good afternoon. Thank you for making time to join today's webinar. As Jo has said, my name is Nathan Andrews. I'm the Head of HR Services at Frettens Solicitors. I do just point out that I'm not a solicitor, I'm an HR practitioner, and anything we cover in our webinar today shouldn't be held as specific advice on any matters that you may be dealing with within your organisations. Obviously, if you do have ongoing matters that you do require advice on, you're more than welcome to contact us or perhaps an HR consultant or indeed firm of solicitors that you're using. But just to be clear, you should take specific advice on specific matters. This is a general presentation on handling the disciplinary process. So just to give you a bit of an idea about what I do in my day-to-day work, as Head of HR Services, I provide consultancy services to our clients. My work is focused on HR case management, the conduct of complex investigations, and providing mediation and conflict resolution services, again, to our client organisations as an independent third party. So I'll be relying on my nearly 20 years experience in within HR to share with you some of my insights on handling the disciplinary process and in particular conducting hearings, which we'll talk about in a little more detail as we work through. So I'm just going to go to my next slide. Jo, just let me know, give me a thumbs up if you can see my slides moving. Perfect, thank you very much. So I just want to give you a quick overview of what we're going to cover in this session. We've got quite a lot of information I want to cover, but I normally allow an hour or so, so I hope you'll find this useful. What I want to talk to you today about is the difference between disciplinary issues and grievances. We're going to touch on that lightly. We'll cover off the ACAS Code of Practice on discipline and grievance matters. We'll also talk about the difference between disciplinary rules and procedures. The difference between misconduct and gross misconduct. Again, they're important topics to consider. We'll also look at dealing with particular issues, conducting a disciplinary hearing and reaching a decision, the right to be accompanied, and we'll just cover off the appeal procedure. So just to give an overview of what we're going to talk about. So the difference between disciplinary issues and grievances, as we all know, I'm sure most of you are likely to be HR practitioners on the webinar, or indeed a business owner who's very experienced potentially in handling matters. So disciplinary issues arise when problems relating to conduct or performance are identified by you as an employer, and you're looking to address those concerns through your established policies and procedures. Grievances, on the other hand, are typically raised by employees who have concerns or complaints about, it could be their terms and conditions of employment, but most usually what I see in my professional practice is it's normally around relationships with colleagues. It can also sometimes be about the working environment, but grievances are very much focused on complaints from an employee that's relating to their employment. So they're the two key differences. Obviously, today's session is focusing on the disciplinary process. So I just want to quickly touch on the ACAS Code of Practice on disciplinary and grievance procedures. So both employers and employees should follow the ACAS Code of Practice. And I want to make that clear. The onus is on both parties to make sure that they follow that those practices within reason. The ACAS Code contains 4 sections. I'm sure you're all aware of this. It has a foreword, which is purely advisory. Then it has an introduction setting out the general principles which apply to all disciplinary and grievance matters. And then there are 2 further sections which deal with disciplinary matters and then grievance matters, respectively. Now, I'm sure you're all aware, but just to make you aware if you're not, that if an employee subsequently brings a successful tribunal claim, the tribunal has a discretion to adjust any awards either upwards or downwards by up to 25% if either party, so that's the employer or employee, has unreasonably failed to follow the code of practice. So it is in everyone's interest, but I'm going to focus in on you guys as employers. It's certainly in the interest of the employer to be seen to be following that code within reason. So that's an important point to note. So I want to talk about disciplinary rules first of all, and then we'll come on to your disciplinary procedure. So the advice we give our clients is that disciplinary rules should set out the standards required of all your employees, that's management or non-management members of staff, to which those rules apply. So that's important that we apply them equally across your workforce. They should make clear to your employees what is expected of them when they're at work. So they shouldn't be written in complicated language. It shouldn't be ambiguous. It should be very clear and easy to understand. And they should also set out the consequences of breaking the rules or failing to reach the required standards you expect of your employees. So I think that's an important point. I always leave this point when you're looking at your disciplinary rules and within your disciplinary procedure or policy. What I advise is that you do keep it as clear and concise as you possibly can. We also advise for disciplinary rules to be contractual terms. And the reason we do that is that if an employee were to breach your disciplinary rules, the employee is essentially in a breach of contract and you could address it as such. However, I do say this now and I'll cover it off again shortly. As our recommendation that your disciplinary procedure or your policy itself should be non-contractual other than the section for disciplinary rules. So you want to give yourself as much flexibility as you can in terms of how you apply your disciplinary procedure in practice. So if you make that contractual, you could cause yourself challenges later on. I'll talk about that in a bit more detail. So in terms of forming disciplinary rules, your policy should ideally be formulated by you as the business. So you should be driving that. But, it's always good practice if you're looking at reworking that policy to involve your employees and potentially any trade union or employee representatives, particularly if you have a recognised trade union agreement in place. But again, getting people involved in formulating your disciplinary rules is really useful, because what you're doing is you're getting people to help you identify the rules that should apply in practice, and you get everyone to sign up to them. So employee involvement is a great way of getting people involved, making people feel engaged, making people feel like they have an input. But obviously you don't lose ownership of the fact that as a business, they're your rules. You need to define them, and you need to make sure that everybody is aware of those rules and how they're going to be applied. So we've already covered that the rules need to be specific and clear and concise, and they should absolutely set out the requirements that are necessary for your place of work. So when you're formulating your rules, think about your business, think about the type of work that you do, your business location, your management structure, etc. Think about everything that identifies you as an organisation, and make sure that your disciplinary rules are essentially reflective of your organisation and the identity of your organisation. Another key important point is making sure that your rules are available to all your employees. That might be that you place a copy of your disciplinary policy on your intranet site, for example, where it may be contained within your employee handbook. And if it is within an employee handbook, you should make sure that that is readily available to your employees. Certainly, I would recommend that you issue a copy of the employee handbook at the start of a new employee's journey with your organisation, so when they're being onboarded or inducted. And I would recommend that you make sure that you get a signed slip back from that employee saying that they've been issued with a copy of that handbook containing all of your policies, and in particular, in this case, your disciplinary policy itself. Another important point to remember is that employees should be made aware of the potential consequences of breaking your disciplinary rules. That can happen within the policy itself. And again, that's why it's so important to make sure that you can evidence that you've issued a copy of that policy to all your employees, so that everybody is aware of the rules that will apply in practice. So what I want to do now is quickly touch on the difference between misconduct and gross misconduct. This is something that can often come up in my consulting work with client organisations, so it's an important point to cover. Many of you may be very familiar with this, but for those that are not, misconduct is conduct which initially requires disciplinary action other than dismissal. So it is serious enough for you to take formal action, but it's not serious enough that you're going to consider dismissing the employee. That's typically misconduct. Gross misconduct is much more serious. It's normally, we refer to it as a deliberate or willful flouting of contractual terms, or it could be something so serious that you feel that the only option available, depending on the findings of any investigation you undertake, is that the employee should be dismissed and their employment terminated with immediate effect without notice. So that is gross misconduct. So just to break that down for you, misconduct, we typically describe misconduct as being a minor breach of company rules, policies or procedures. It might be minor damage to your company property. It might be unsatisfactory attendance or poor timekeeping. It could be unauthorized absence or failure to meet appropriate or expected standards of work. Although I caveat that with, if you're dealing with a failure to meet expected standards of work, it may be that you need to look at using your capability procedure if you have one, and that might be a more appropriate policy to refer to rather than the disciplinary procedure itself. In terms of gross misconduct, I've got a list here that I'm going to run through with you. So we've already established that gross misconduct is typically a single act of misconduct that is so serious that on its own it would justify the employee's employment being terminated without notice. So we call that summary dismissal. There's no statutory definition in terms of what constitutes gross misconduct, so it is up to each employer to define the types of conduct that will be regarded as gross misconduct. So again, it just speaks to the importance of you giving consideration to the development of your internal disciplinary policy and making sure that that is largely fit for purpose for your organisation, taking into account all the uniqueness about your business, the type of work that you do, the structure of your teams, and so on. So I think, don't overlook the importance of making sure you've got a disciplinary policy in place that is fit for purpose and is also regularly reviewed to make sure that you are complying with employment law. So just to cover dismissal. So before dismissing an employee for gross misconduct, you do still need to investigate any allegations being brought against the employee and give the employee the opportunity to respond to those allegations before you reach any decisions about what you're going to do following any disciplinary hearings. So I want to stress that, and I probably will repeat myself later on as we work through the webinar. So just to give you some examples of gross misconduct, and many of us will have seen these examples, they're pretty standard, but let's just run through them for those that maybe are coming at this from a new perspective. So theft or fraud will be typically considered as an act of gross misconduct. Physical violence or bullying in the workplace, deliberate or serious damage to company property, serious misuse of an organisation's property or name. It could be deliberately accessing internet sites that contain offensive material such as pornography. It could be offensive or obscene material in the workplace. It could include serious insubordination, so that would be potentially refusing to follow reasonable management instructions as an example. And it could also be an act that we consider brings the organisation into serious disrepute. So it has the potential to damage the reputation of your business. These are things that are typically considered acts of gross misconduct. Another point to touch on is incapability at work, which is as a result of consumption of alcohol or illegal drugs. Again, that would be considered an act of gross misconduct, and that you would want to deal with that seriously and robustly. So it's not an exhaustive list that I've given you. There'll be other examples, and there may indeed be specific examples that are unique to your organisation. Hence why I say when you're formulating disciplinary rules or looking at your disciplinary policy, you should be really considered about your organisation and what it is you need. Right, bear with me. So disciplinary procedures. So bearing in mind, we've just covered off disciplinary rules. So, and they will be included in your disciplinary policy, but so will your disciplinary procedures. So disciplinary procedures are created to provide a framework to support line managers in applying your disciplinary policy in practice. So it's a framework. It should be a document that is informative and helpful to line managers when they're handling matters that fall under the disciplinary policy. They should help managers deal fairly and consistently. These are really important points. Fairness and consistency is essential when you're dealing with disciplinary problems which may arise within your business. And you want to make sure that, again, your policy really equips your line managers to deal with matters with confidence. As I said earlier, it is advisable for the procedures to be non-contractual so that you can retain as much flexibility as possible when you're implementing them in practice. Bearing in mind as well that you may have line managers who aren't as skilled or confident or well-versed as we are as HR practitioners in dealing with these matters. We want to make sure that when we're giving them a policy, such as your disciplinary policy, it is easy for them to work with. So it's easy to understand, it's clear, it's concise, and it avoids legal jargon or complex elements of employment law that which they may not need to know. Because essentially, when you're working through a disciplinary matter, and the line manager may be chairing a disciplinary hearing, there's a process to follow, but it should be very practical. So I just wanted to stress that. Obviously, we will all know from an HR perspective that we shouldn't act in a way that could destroy the trust and confidence that exists between a business, so you as employers, and your employees. So that is something to bear in mind, and that speaks to the need for us to behave reasonably and fairly towards our employees. Now, I just want to cover off, if your disciplinary procedures are contractual, and I do see this a lot, there are clients that we work with who, for whatever reason, have legacy documents that are contractual, and sometimes that can be overlooked, and that can be problematic. So what I would suggest is, review your policies, check whether they are contractual or not. If they are contractual, then it's really important that you follow your disciplinary procedure to the letter. If you fail to follow that policy and it's contractual, an employee could suggest that you breach their contract and then bring a claim for a breach of contract. So it is very important that you are familiar with the contractual status of your policy. And as I say, if it's contractual, my recommendation is you follow it in its entirety. And that would apply even to short service employees. So that's employees with less than 2 years. Because ultimately, if that policy is contractual, whilst the employee doesn't have the right to bring a claim for unfair dismissal with less than 2 years service, they could bring claims for breach of contract. So you just need to bear that in mind. The other issue you potentially could face is if you don't follow your disciplinary procedure when it's contractual, that could give rise to constructive dismissal claims as well. So we just need to be really considered if you do have contractual policies. Hopefully you won't, because that can be quite restrictive, especially if you're dealing with things for short-serving employees where you want to have a level of flexibility. But obviously, if they are contractual, then you just need to work with that and just be mindful of it, essentially. So I just want to touch on forming disciplinary procedures, because I think this is an important point. Many of you will have heard, probably through your professional training, about the concept of natural justice. Natural justice is a legal term, essentially, but it's been largely replaced in practice by the duty to act fairly and reasonably. And so that is really important. And when we talk about acting fairly and reasonably, what we mean is, and this is specifically focused on dealing with disciplinary matters, is that the employee who's subject to potential disciplinary proceedings, they should be informed in advance of any disciplinary hearing. That should include the allegations that are being brought against them, and that should also be made available to them together with any evidence that you're going to rely on at disciplinary hearing. They shouldn't be subject to an unbiased or impartial decision-making panel. Whoever's chairing the disciplinary hearing, whether that is a single manager or indeed you may have a policy that says that there will be a panel of decision makers, those parties shouldn't have any involvement in proceedings. They shouldn't be involved in the investigation. They shouldn't be subject to any complaints or grievances that are potentially related to the disciplinary matter under consideration. They should be completely impartial and independent of proceedings. It's also important that employees, again, we're talking about acting fairly and reasonably, that we give them the opportunity to challenge any allegations made against them before decisions are reached at the conclusion of any disciplinary process. And as we all know, employees at a formal disciplinary hearing do have the right to not only be accompanied, but they also should be given the right to appeal any decisions that have been taken against them. So again, these are important points to consider, ones I'm sure we're all familiar with, but it's a good refresher. So thinking about acting fairly and reasonably in a little more detail, good disciplinary procedures, I would suggest, should include the need for them to be in writing. So you want your disciplinary procedures to be in writing. They should specify to whom they apply, which will be your workforce, and they should provide for matters to be addressed without undue delay. That's really important. And I often see or get involved in supporting clients with matters where there's been a delay in dealing with situations in the workplace, and that can often give rise to things becoming more contentious and more complicated to address and resolve. Disciplinary procedures should be non-discriminatory. So that again is important when you're formulating or writing your policy or reviewing your existing policy. You just want to make sure that they are not discriminatory against any of your employees in any way. They should provide for proceedings, witness statements, and records to be kept confidential. Obviously, that's really important. They should indicate the disciplinary actions which may be taken, and they should specify the levels of management which have the authority to take any form of decision making at the conclusion of a disciplinary process. These are all important points to remember. They should also provide or allow for a careful investigation before any disciplinary action is taken. So that is particularly important, especially when you're dealing with matters for employees who have 2 years service or more. So I think that is really important. They should also allow for employees to be informed of the complaints against them. I've already covered that this in a little more detail. And again, it's really important that you provide the evidence you're going to rely on in good time so that the employee has the opportunity to prepare their case before they attend that hearing. So it's about being really organised. If you're dealing with a matter that feels reasonably complicated, you need to make sure there's sufficient time to allow people to see the evidence, to understand the evidence you're relying on, to be able to comment on that or challenge it if they feel that evidence is incorrect. Again, we've talked about allowing people to be accompanied to formal disciplinary hearings. That is important. And again, it is just making sure, and I want to finish off on this slide with this particular point being made, that you do act reasonably and fairly. And in doing that, you would be looking to follow the ACAS code of practice. Again, really important point. Get yourself really familiar with the ACAS code and make sure you follow that in all circumstances so that you can demonstrate should you face a claim in the employment tribunal. Hopefully you won't, but if you do, you can demonstrate that actually within reason we followed a fair and reasonable process in all of the circumstances. Okay. So I just want to cover off dealing with particular issues. This is often quite a popular section of this type of webinar, but absence, for example, is a common theme that we deal with and see on a day-to-day basis. So if you are dealing with absence issues, you should ensure that employees know who and when to notify when they are absent from work. In cases of sickness, they should know when to self-certify, i.e. the first 7 days, and when they require a fit note from their general practitioner. Again, that's for absences lasting 7 days or longer. As employers, we should be monitoring absence levels proactively by keeping good records which show, lateness, for example, and the duration of any absences and the reasons for those absences. This is really important information for you to gather because it enables you to be proactive in monitoring attendance levels and identifying any issues. And that could be where, there may be underlying issues that you're not aware of or an employee's not told you about that you can pick up early on and provide support and assistance with. Obviously, it's a useful way of managing, repeated periods of short-term absence, which could be for various reasons that you need to address with the employee. So gathering information is really important. Again, I will always recommend if you're dealing with short-term periods of absence, it's really important to conduct a return to work interview. That will aid you in your record keeping. It will assist you in having open lines of communication with your employees about their absences, but it'll also keep you consistent. People will know that if they're taking periods of absence, that you're going to follow up with them, A, to make sure that they're well and they're fit to return to work, but B, you can address any issues as they arise. And early on, if you think someone's absence levels are going to become an issue, we should be letting them know early on to say, look, your absence levels are kind of reaching a stage where we're going to be concerned. And so it puts them on notice that they continue to have repeated periods of absence. It should be no surprise if you start to take more formalised action with them. So absence on medical grounds, this is typically, I'm talking about things like injury, disability or illness. They should be treated as a capability issue. There are other types of absence which may give rise to disciplinary issues, and that is typically absence without authorization. And again, if you are dealing with that, where someone's taking periods of absence without it being authorized, that could potentially lead to dismissal on the grounds of conduct. But again, you would need to follow your disciplinary procedure. You're going to get fed up with me saying that as I work through the webinar. Medical absences, they should be treated sympathetically and with compassion for obvious reasons. If someone's on a medical absence, it's largely due to the fact that they're going to be unwell. There might be a health condition, sorry, that they've been diagnosed with, that you want to show that you're being supportive around. But that said, it doesn't mean you can't manage absence on medical grounds. But it just, my default position always is, let's treat this sympathetically and adopt a supportive approach, and then work away from there if we feel this is going to become a long-term issue. What we always recommend when we're working with clients, that when you're looking at handling medical absence cases, you should consider how soon the employee's health and attendance will improve. So that gives you an indication of, is this going to become a long-term issue that we need to manage, whether there's any suitable alternative work available that could allow the employee to return to work safely. So again, I'm talking about potentially adjustments, but you would potentially need to look at consulting occupational health to make sure that person is fit to attend work, if you can offer them amended duties, as an example. You should also take into consideration what effect their absence will have on the organisation as a whole, whether there have been any other similar cases that you've dealt with, and how they were handled previously. You also want to consider whether the illness is as a result of a disability, particularly important. If you are dealing with something where you think there could be a disability, you don't want to be seen to be treating an employee less favourably on the grounds of their disability, or unfavourably for a reason relating to their disability. Really important point to consider. I always advise clients, if you think this is a disability is a potential issue, take professional advice and make sure that you are on solid ground when you're handling these types of absences. I hope that all makes sense. So unexpected absences, again, they should be investigated promptly. That's really important. Let's not leave any unnecessary delay in dealing with those issues. And the employee should be asked to give an explanation for any period of unexpected absence. If there are no acceptable reasons for the absence given to you when you're investigating, the matter should be treated as potentially a conduct issue, and it should be dealt with under your disciplinary procedure, in which case the employee should be told what improvement in attendance is required, and they should be warned of the likely consequences that could follow if they fail to improve and meet your expectations in that regard. But again, I want to be really clear here. You should investigate, go on a fact-finding exercise to make sure that there are no underlying health issues that are contributing to these unexpected periods of absence. So just be mindful in that regard. Persistent absence should be dealt with promptly. Again, you're going to hear me say that word a lot, promptly, but it all should be dealt with firmly and consistently to show your employees that their absence is regarded as a serious matter, and that you are likely to take formal action with them if you don't see an improvement. So it's just, being proactive in terms of managing those situations as they arrive. So just talking about poor performance, obviously we all know the importance of performance management and setting realistic and measurable goals or targets or standards of performance. That all still applies. Again, careful recruitment selection should help minimise the risk of you experiencing performance issues. But as we all know, sometimes things don't work out as we had hoped or planned for, and we may find ourselves in a situation where we need to deal with poor performance. So if you are addressing poor performance with an employee, you should explain the required standards that you're expecting from them. Ideally, this would also be explained at the outset of their employment, or if you're promoting someone internally, you should set out your expectations from the moment they're promoted. You should make sure that you've got job descriptions in place that set out the main purpose and scope of the job role, and that everyone is clear on what is expected from them. I think that's really important. Again, I'm not going to go into this in any real detail, but proper training and supervision, that's essential to helping people reach satisfactory standards of performance. So we should, as line managers, as HR managers or practitioners, we should be very proactive in working with our employees and helping them to succeed, and making sure that we've got the tools in place in order to do that. It's also important to make sure we've got the tools in place that we can rely on when things don't work out and we do need to, reset the boundaries or assess or evaluate performance. We should have documentation that is robust and offers us a framework to apply in practice when we're addressing issues. Performance appraisals, they can be a useful way of helping you assess performance. That being said, I don't believe the appraisal system should be used as a way of performance managing when there are issues. I personally am not a big fan of the appraisal process, or certainly the annual appraisal process, because typically over the last 20 years of doing this work, all I see when people have an annual appraisal is they get prepared for a discussion with their line manager at one point in the year, and when that conversation ends, there's a form that's signed by both parties, and then it gets filed in their personnel file, and it gets forgotten about until the upcoming appraisal the following year. So my preference is to have regular, consistent, and robust conversations with people throughout the year. Certainly when I was an in-house HR manager, my preference was to work with the management team and get those managers to have, regular 6 weekly one-to-ones that could contribute into an annual appraisal, but it allowed the manager to have regular meeting points throughout the year with their employees where they can discuss what's working well, identify any performance issues or support that's required, but it also allows the line manager to pivot and to be adaptable in terms of, when you have an appraisal once a year and you set goals or objectives for the upcoming 12 months, a lot can happen in 12 months. The business can change, the structure of the organization can change. You might face challenges that you hadn't anticipated. So by having regular one-to-one contact with your employees, it does enable you to adopt flexibility when setting objectives or when asking your employees to work on specific projects or activities. So I think that's an important point to consider. Performance, again, should be monitored really closely during a probationary period. Your probationary period is a really great opportunity for you to make sure that, certainly if you've got somebody new into your business, make sure they've been onboarded, make sure they're familiar with your systems, ways of working, colleagues, if you've got a buddy scheme, making sure that that's working well in practice, because the intention should be that you get to the end of the probation period and that person is successful, they've bedded into the organisation, and they're largely competent in their role. So again, I can't stress that enough. Okay, and one that's normally a popular topic of discussion is if you're dealing with issues where the police are involved and the police are potentially conducting an investigation into matters. So what we say is where a matter is under internal investigation, but it also involves the police, employees can, and in many cases, shouldn't delay their internal process pending the outcome of police inquiries. Often I get asked, about, how long should I delay conducting my own internal investigation if the police are involved? And I always say, look, you should take advice. I would recommend taking professional legal advice, but oftentimes it's not practicable for you as an organisation to delay any internal investigation while you wait for the police to conclude theirs. In reality, a police investigation is likely to take many, many months. It may mean that you've got an employee that is on suspension, depending on the matter under investigation. But I would suggest if the police are involved, it's going to be serious. It's likely to be potentially a gross misconduct matter. And you've got to ask yourself, how reasonable is it for you as an employer to have an employee on paid suspension? Bearing in mind, when you suspend an employee, it's on full pay. How reasonable is it for you to have them on full pay suspended for a long period of time? So it may not be practicable for you to delay any investigation whilst you wait for the police to conduct their own. That being said, if you are thinking that you need to proceed with your own investigation, you should be mindful of the police investigation, and you should be mindful of any of your actions and making sure that it doesn't prejudice any police investigation. Hence why taking early legal advice is often a preferable position to be in, so that you know that when you're making decisions that you've consulted with a solicitor to make sure that you're on solid ground before you go ahead. Another important point to consider is that obviously if an employee is subject, and I've dealt with this many, many times, and I handle complex investigations on behalf of clients, oftentimes police will be involved, and often we find that if we are interviewing an employee as part of our own internal investigation, they're often resistant to answering questions because they're thinking all of the time, is this information likely to be made available to the police? And am I going to incriminate myself by engaging in any internal investigation? There are ways around that. For example, I've had individuals say, actually, I don't feel able to engage in this investigation process for obvious reasons. And then therefore I do everything I can to demonstrate that I have offered them alternatives. For example, I'll make available my list of questions that I want to cover off with you. They can take that to their solicitor, for example, if they so wish, if they've attained legal counsel. And they can then provide their written submissions for me to consider as part of my internal investigation. Another important point to consider, and it's a fairly obvious one, but sometimes it gets overlooked, is that the difference between a police investigation and an internal HR investigation is that we're working towards different burdens of proof. So if the police are conducting a criminal investigation, their burden of proof is going to be beyond all reasonable doubt. But for an HR or internal workplace investigation, the burden of proof is based on the balance of probabilities. And what I mean by that is what is reasonable for us to believe in all of the circumstances. So it's a very different burden of proof. I've seen cases, for example, where the police, following their investigation, don't decide to prosecute, but actually following our own internal HR investigation, we've made a decision to dismiss, for example. So, as I say, it goes back to that burden of proof and the key differences between both. But I do want to stress and make clear that, yeah, whilst, oftentimes, as I've said, it's not practicable for you to hold any internal investigation whilst you wait for the police to conclude theirs. You should take advice. So proceed with caution, because you don't want to do anything that leaves you exposed to accusations or complaints that you prejudice any kind of legal/criminal investigation being conducted by the police themselves. Okay, we're nearly there. Okay, I know it's a meaty topic. So conducting a disciplinary hearing. So there are no legal kind of rules around a disciplinary hearing. A lot will depend on the particular circumstances and whether you have set out any procedural guidelines as discussed earlier. However, what I say is, what we do know is that when you're conducting a disciplinary hearing, employees should be invited in writing. They should be given sufficient notice of that hearing. They should also be told in advance what allegations are being made against them. And you should also send them the evidence you're going to rely on at that disciplinary hearing in good time for them to be able to review that and to prepare their case. So that's a really important point. We also know that employees do have the statutory right to be accompanied at any disciplinary hearing, and that should be set out in your invitation letter. So that's another important point to consider. You don't want to be seen to be doing anything that deviates from the ACAS code of practice. In terms of conducting the hearing itself, at the introductory stage, what I always recommend is that the chairperson introduces those present at the hearing, including the note taker, and they should be clear with those that are attending the hearing, the roles of everyone who is present. So that's really important. You should cover that off in your invite letter so there's no surprises. But when you're introducing everyone at the hearing, take the time to make sure that you do that justice, because it helps everyone relax into the process rather than feeling unsure about what is likely to take place. Okay. The other important point to remember when you're conducting a disciplinary hearing is essentially setting out the nature of the complaints. So it's just summarising the allegations being made, reviewing the evidence during the hearing with the individual, giving any witnesses an opportunity to comment. If witnesses are being invited to attend, oftentimes that's not what happens. What we rely on is witness statements, and the respondent will do the same. But sometimes I have been in hearings where a respondent says, actually, I want witnesses to attend, and I cover that off in the invite letter saying, if you do want to call witnesses in person, you need to let us know in advance so we can make arrangements for that to happen. But again, it's a really good practice to allow or certainly to inform the respondent that they can do that if they wish. Again, make sure you clarify during the hearing that the employee has received the evidence bundle that you're going to rely on during that hearing, and ask them to confirm that they have had opportunity to review that in a meaningful way, because again, this speaks to acting reasonably and fairly. So during the hearing, the employee should be invited to state their case, they should ask questions, and they should be allowed to present any evidence, as I've said, including calling witnesses. If the witnesses are unavailable to attend, the hearing should be adjourned unless it's clear that the evidence that is going to be provided is not going to essentially affect the substance or the nature of the complaints under consideration. But most usually I would say, look, if somebody wants a witness to attend and they're not available, just adjourn. It's good practice. It shows you're acting reasonably and fairly in the circumstances. You should absolutely take note during the hearing and consider any explanations or special circumstances that the employee puts forward during that hearing. And if they've not offered an explanation, you should ask them to do so, because that is particularly important. You're going to want to take that into consideration. during your adjournment when you're weighing up what action to take. You should be formal during the hearing. I'm formal, but I'm polite. It's a formal meeting. Everyone needs to be clear that this is a formal process, and there could potentially be a formal sanction in line with your disciplinary procedure as an outcome. So we want to give the meeting the importance it deserves. So I always say adopt a formal but polite approach. Use a good mix of questions that are open-ended and closed as necessary to gather information that you need to make decisions at the end. And you also want to make sure you clarify all the issues under consideration so that when you conclude that hearing, you are confident you have all the information you need to make any decisions. Okay. So just touching briefly on the decision outcome, just conscious of time, but we are nearly there. So unless the case is very straightforward, we always advise that a hearing should be adjourned before you reach any decision. I call it the olden days, when I first started out in HR, it was often seen to be, an accepted practice that you would hold a disciplinary hearing and you would adjourn for 15 minutes, maybe half an hour, depending on the matter under consideration. And then you'd bring the employee in and you would communicate verbally the outcome. We actually say, no, we don't, we shouldn't do that today. What we should do is adjourn, and depending on the matter, allow a 24-hour or 48-hour period before you then draft your outcome letter, writing to the employee and confirming in writing the decisions you've reached. And what that shows is that you've not made any knee-jerk decisions. You've taken time to consider their representations, because bearing in mind at the disciplinary hearing, you may have met with the employee. Well, the chairperson won't met with the person at the investigation meeting. So if the employee or the respondent attended an investigation meeting, they would have made representations at that meeting. But you've got to remember that the chairperson of the disciplinary hearing, if they've not been involved, as is good practice, then they should be coming at this completely brand new with a fresh, open perspective. And so they want to be able to demonstrate that the information they've gathered during the hearing, including the representations made by the employee, they've gone away and thought about it. They've weighed up the information that's been shared with them. They've looked at the evidence, and then they've made their final decision. So that's really important. Also, allowing a period of adjournment before you reach your decision does allow for you to, conduct any further investigation. It might be you've got some questions that you just want to cover off with somebody, and that allows you to do that and to demonstrate that you've gone and explored any information that you felt was missing to enable you to reach a fair conclusion at the end. The employee should be told about the result of any further investigations that you may or may not undertake, as the case may be. But if you are undertaking further investigation, be clear with the employee. And again, if you're gathering new information, no matter how small, give them the opportunity to respond to that, give them the opportunity to comment on that and take their responses into consideration. That's just really good practice. And I think, should you, depending on the outcome and depending on the matter that you're dealing with, should you decide to dismiss, for example, it's important you can demonstrate that at every opportunity you've conducted a fair and reasonable process. If the facts are disputed, the manager who's conducting the hearing should decide which version they prefer. And again, you're going back to the balance of probabilities. What is reasonable for you to believe in all of the circumstances, including the evidence that you have reviewed? We've covered this. Do workers have the right to be accompanied at disciplinary hearings? Yes, they absolutely do. That is an important point to consider. It's normally reserved for a colleague or a trade union official. That being said, I've dealt with situations where an employee hasn't felt able to bring a work colleague, for example. They're not a member of a union, they don't want to be accompanied by a union official, but they have asked me, can I be accompanied by somebody else? Might be a family member, for example. And I will take any requests seriously, and I'll consider them. And if I think it's helpful to allow somebody else that doesn't fall within the category of colleague or trade union official, I may do that. But again, what I never do is allow someone to bring a legal representative with them. So it might be that, and I've done this before on occasions, I've allowed a family member to attend because actually the person suffered with anxiety and it meant that they felt they were able to contribute in a meaningful way to the proceedings. So again, don't just make a knee-jerk decision to say no, show that you've considered any requests and document your consideration. And then finally, the appeal procedure. As we all know, if you are going to impose a disciplinary sanction on an employee following a disciplinary hearing, the employee does have the right to appeal any sanction, and you should clearly have that set out in your disciplinary procedure. And we should make it clear in any outcome letter that we issue to the employee that they do have the right to appeal. We should set out the timeline for them to submit their appeal. We should make it clear to them that their appeal must be submitted in writing, and that it should clearly set out the grounds for their appeal and who they should address their appeal to. And as I say, it's a really important point to communicate to the employee. Make sure that you also communicate that verbally to the employee in terms of checking in that they've received your outcome letter. Bearing in mind you're going to have a period where you've adjourned and you're going to write to them. So I would always check in and say, look, have you received my outcome letter? Also to remind you, you do have the right to appeal, and that is detailed in the letter itself. And there ends our webinar. I appreciate it was a whistle-stop tour, and I'm sure there's questions, so I'm going to hand over to Jo.
Yeah, there's quite a few. Okay, so Gabby's asked what to do if a colleague breaches a policy, which is a conduct issue, but they say they were unaware that the policy existed and play ignorant.
Well, I think this is a really good question, and I do see this come up a lot actually with policies. It goes back to, do we have evidence that that person has been given a copy of said policy? And if we've got no documented evidence, is it reasonable for us to believe that they will have seen a copy of that policy? I think they're the most important questions. Ideally, you would, to strengthen your position, you'd want to be able to demonstrate that you've got documentation that supports that they've been given a copy of that policy. But obviously, in the absence of that, I would be looking at, I'd be taking into consideration their length of service, how readily available are the policies, if it's on an intranet site, is that widely known, for example? And also, you could ask the question to the employee. It goes back to doing an investigation. And oftentimes, people think when you hear the term "I must investigate," that investigation process is going to be onerous and long and drawn out. And actually, that isn't the case. An investigation will only ever be as complex as the matter under investigation. So if it's a straightforward issue, your investigation might simply be having one or two very brief conversations with an individual to establish the facts. But again, in the absence of any documented evidence, you're going to have to look at what's reasonable for you to believe in those circumstances. I hope that answers that.
Helen's asked, at what point would the employer inform their insurers at commencement of investigation, upon conclusion of the disciplinary process, or in the event of an appeal?
Yeah, if you've got insurance in place, so I'm assuming you're probably talking about employer protection insurance, or you often find in general kind of business insurance policies, there will be legal expenses covered, for example. So if you think that a matter is going to become legal, there's no harm in you contacting your insurer. And what I would always say, and what we say to our clients is, do you have insurance in place? If you do, contact them at the earliest opportunity, bearing in mind an investigation isn't a legal matter, that's an internal workplace matter, but it is good practice, I think, to speak to your insurers and say, look, we've got a situation, we think we need to investigate, we have got legal expenses cover in place, what do we need to do to comply with the terms of our policy? So I would do that as early on as possible and make sure that any advice or recommendations given by the insurer or a broker that you're using is documented in an email or in writing so that you can rely on that later.
Rose has asked, can you start a disciplinary process with an employee who has high levels of absence, or does this need to be managed as part of a capability process?
Really depends on the absence and whether you're dealing with long-term absence, which is one period of absence that extends over a long period of time greater than 4 weeks, or if you're dealing with frequent periods of short-term absence for varying reasons. Varying reasons is really important because if you've got somebody that is, I'm off with a cold, I've got a migraine, I was sick, I had DMV, I had a virus, they're all varying reasons which make it easier for us to challenge their absence levels. What you've got to look for if you're dealing with frequent short-term periods of absence is, are there any patterns that might suggest there's an underlying health condition? So what I always say is get really curious, ask lots of questions around the employee's attendance and their reasons for absence, pull together that information. So your absence data, really important, you're going to want to rely on that. But don't make a knee-jerk decision when dealing with absence. If it's frequent short-term periods of absence, that potentially could be a conduct issue. If we're satisfied there's no pattern that might suggest otherwise, i.e. an underlying health condition, if it's a long-term period of absence, that's one period, as I said, extending over a significant period of time, then that is you're much more likely to have to deal with that as a capability issue, potentially. So again, depends on the circumstances, but it's just weighing up your options really in terms of what am I dealing with and making a decision around, do I need to take advice? That's my answer in that regard.
Jeanette's asked, if the person carrying out the investigation is a friend of the manager, can this be frowned upon at the employment tribunal?
Well, I mean, yeah, look, what I would always say is if it's well known that there is a friendship, an established friendship, everybody knows that quite widely within the business, you are going to leave yourself exposed to challenge that the investigating officer lacked impartiality because actually the line manager potentially had a viewpoint. They shared that point of view with the investigating officer and could have clouded their judgment or their thinking. However, if you're in a small organization and you've got limited resources, limited management resource internally, all you can do is do your very best to separate out the roles of the investigating officer and any decision maker at the disciplinary hearing, bearing in mind that the investigating officer doesn't make decisions, they fact find and present their findings in a way that's easy to understand and interpret. And it's then for anybody who's been appointed as a disciplinary officer to make decisions once they've considered the evidence and met with the employee at a disciplinary hearing. So I think, my preference would always be if you think that there is a friendship between the investigating officer and potentially the line manager who may hear any disciplinary hearing, should the allegations be founded from the investigation, then if you can make a change to who conducts that investigation, I would suggest you do so. It's far easier to take these decisions now to safeguard your position later than to try and defend suggestions that the employer was subject to a biased investigation against them.
Diane's asked, if you discover something that may be illegal during an investigation or disciplinary, what are your responsibilities in terms of reporting it to the police, and how does it work with the confidentiality of the process?
Yeah, again, this is a great question, and what I would always say is, always take advice. But I think if you've discovered that a crime has taken place, I would suggest you're probably duty bound to report that to the police, especially if it's a significant issue. But again, I can't think of any examples off the top of my head. No, none's coming to me because I'm on the spot. But what I would say is, if you're dealing with something in that regard, you should take advice. I get the point around confidentiality. However, if you've uncovered that there is criminal activity taking place, you can't unknow that information, and you could argue that ethically, should you not take action or report it if it's that serious where you think actually this is illegal and that action should be taken. So yeah, take legal advice for sure. And I'd recommend that to any HR practitioner. No matter how experienced we are, we're not lawyers. I would always get something risk assessed in that regard. But yeah, I think, the reality is you can't unknow something if you've discovered there's illegal activity taking place within your business. You've got to think about how you protect the business ultimately and your other employees, depending what the issue is and whether there's any risk involved.
Claire's asked, do you legally have to give notice for an investigation meeting?
No, investigation meeting, essentially, I mean, we always have this age-old debate. Is it informal? We often will say, well, it's an investigation meeting is informal because there's no outcome, there's no sanction coming from that meeting. But the reality is it forms part of a formal process because you're gathering information, you're going to have a note taker present, you're going to rely on that information later on. But no, there is no need to invite an employee to an investigation meeting or indeed to give them any notice. Or indeed to even advise them of your questions in advance. In fact, I would suggest that we don't do that because what I prefer to do is to sit with somebody and ask them my questions and to capture real-time responses. So no, is the short answer. I mean, there's nothing to say, and it's good practice if you invite someone to an investigation meeting that you do it in writing, and you can give them a summary of, I want to invite you to an investigation meeting. You're not the subject of that investigation unless they are. And broadly speaking, this is what we want to talk to you about. There's nothing wrong in doing that, but you're not required to do so. You can simply set up in a meeting room. If you know the individuals you need to speak to or on duty, you go down and you pull them into the meeting room and explain to them what you want to discuss.
Jeanette's asked if there are disciplinary matters involving a colleague based in Europe, should the ACAS standards be utilised?
Well, this is an interesting point because, yeah, if you've got an employee based in another country, it could be argued that local labour laws could apply. So, and I'm going to be like a politician on this one and say to you, there's no clear-cut answer, take advice. And the reason I say that is that, yeah, that there is the real potential that local laws apply. And again, you'd have to assess it on a case-by-case basis. But, in all circumstances, I would suggest that if we are going to take action, we certainly would want to comply with our own codes of conduct. So the ACAS code of conduct, for example, because if the employee is employed by the UK-based employer, but their work is being done abroad, I would suggest you would still want to be seen to be following our local laws, but not overlook the fact that we may have to follow local labour laws of the country where the employee is based from. So again, it's more of a legal question than really an HR question, but it is something to consider. There is the possibility that local labour laws could apply. So always take advice.
Charlotte's asked, does it have to be a different HR representative conducting the investigation and doing the disciplinary meeting?
Yeah, if the investigating officer is a member of the HR team, then they shouldn't really have any involvement in later proceedings, including note taking. And the reason I say this is people will argue that if the individual is only attending to take notes and not taking part in the meeting, and they're not, having any involvement in decision making, the reality is you're going to have a hard job to defend, in my opinion, that in the adjournment, that person has not had conversation with the chair of the disciplinary hearing, and has not had an influence on the outcome. So my view is, if you can keep things separate, absolutely keep it separate. It's far easier to do that than to try and defend your position for someone simply making an assertion that actually, I think this wasn't a fair process because the investigating officer was also the note taker at the disciplinary hearing. And if they are a member of the HR team, it is normal for the HR representative who may be present to take notes to give advice on matters of law or procedure. And so again, it's just be mindful of the fact that you could leave yourself exposed to challenge that did that HR representative go beyond note taking? Did they give any advice or guidance on law or procedure? And if so, what advice did they give? So keep it separate if you can. Appreciate in small organisations that's not always possible. But that being said, if you've got a PA within your organisation who's competent at taking notes, there's nothing wrong with using someone outside of the HR department, especially if you're a standalone HR practitioner. So don't be worried about using admin support staff, for example. As long as they're competent at taking notes and they're able to maintain confidentiality, get someone else to do it. That's my view.
Jeanette's asked, in settlement agreements, do we have to detail the financial payments? If not, what are the repercussions for the company? And then the second bit is, do we have to pay a loss of employment payment in a settlement agreement?
Yeah, so this is very general, I'm not talking about any specific issue, but yeah, within a settlement agreement, you would set out the contractual entitlements that would be due. So, for example, you're going to talk about the termination date. So if the termination date was the 10th of April, you're going to pay that employee up to the 10th of April, and that becomes their final date of employment. Then you're also going to talk about notice pay. So you'll talk about making a payment in lieu of notice. You don't typically give monetary figures when you're talking about payment up to the termination date and payment for in lieu of notice. You would just stipulate that they get paid up to the termination date and they're also entitled to X amount of payment in lieu of notice. You'd also, again, do the same in regard to holiday. So it's very normal for you to say, you have 5 days accrued holiday which has been untaken. This will be paid up to you in your final salary payment. And then there will be a section talking about the termination payment. Now, the termination payment is important because the termination payment is a compensation payment, and the compensation payment is related to compensation for the loss of employment. And that payment is typically deemed not to be tax deductible. So the employee doesn't pay tax or NI deductions on that termination payment. Although I say that, I always follow up with saying I'm not a tax advisor, but it is standard common practice that the first 30,000 of any ex gratia or termination payment within a settlement agreement is tax free. So that would be, when you're talking about the termination payment, you would give a figure, because the employee needs to understand what is my termination payment, because essentially that is, you're paying them that money as compensation for the loss of their employment in return for them signing away their rights to bring certain claims against you later on. So you want to be clear on what that figure looks like. Sorry, Joe, just read the end of the question, because I think I've forgotten.
Sorry. Do we have to pay a loss of employment payment in a settlement agreement?
Oh yeah, that's a termination payment. Yep. So that is your termination payment. So again, yeah, if you're in that situation, get really clear on what the termination date is going to be. You pay up to that termination date. The employment ends on the termination date. You then pay up their any notice pay. And then obviously if there's any holiday, that gets paid up. That's usually paid in your payroll. So on the next payroll run, and that will be taxed at source. So that will have PAYE deductions, because payment in lieu of notice, or pylon as we call it, that's a salary payment, so that is subject to tax and NI. Holiday pay, the same thing, it's tax deductible, so it's only the termination payment that is not. I hope that answers that question.
There's just a couple more questions left, Nathan.
Yeah, of course.
So Jeanette's asked, what do we need to do to facilitate neurodiverse colleagues who are undergoing the disciplinary process?
Oh God, that's quite a broad question. Again, it's going to be case specific. If you've got people that who are neurodiverse, what adjustments do they need us to make? I'm all up for making adjustments. And I'm very genuine when I say that. If someone has an issue, you tell me what it is you think I can do to help you, and if it's reasonable and practicable for me as an employer, I'm absolutely going to look at doing that. I've got no desire to make things difficult for anybody. But what I do say is what is being asked of the business reasonable? And that's always an important point that often employees overlook. They see the term reasonable adjustments and they'll say, well, that's a reasonable adjustment. And actually, if you do some digging, sometimes it's not always reasonable. And so again, it's a bit of like a politician's answer. Depends on the situation. But if you can accommodate any requests for adjustments and you find that they're reasonable, it's not going to cause you an issue, make the adjustment and demonstrate that you are a reasonable and fair employer who is doing your very best to support your employees. So it's a really topical question. But yeah, I hope that helps.
Right, the last one. Steph's asked, I've always avoided this, but any guidance if employees want to record the disciplinary meeting?
Oh, this is another topical question. So my position is I record all my meetings. My view in today's day and age is if I'm not recording it, the employees like to be recording it. And actually, I would far rather rely on a typed transcript from a recording than handwritten notes taken from a note taker, only for the employee to come back and say, I don't agree with your notes, and actually I took a recording. Now, I often get asked the question, if someone's taken a covert recording, can I discipline that? Can I discipline them for that? Potentially you could, if you've got it set out in your policies that taking covert recordings is unacceptable, and you've said to them at the start of a hearing, we all agree this meeting's not being recorded, and we've got a note taker present who's taking handwritten notes, then yes, you could potentially take action against them. However, it doesn't help you overcome the fact that if your note taker has missed key information that's particularly relevant, you're going to leave yourself exposed to potential complaints around the quality of the note taking. So my position is I record. I say to all attendees, I'm recording the meeting. It aids good note taking. What I say to the individual is, hey, once you've reviewed my typed transcript from the recording, if we all sign those notes and we agree that they serve as a fair reflection of our key discussion points, then I'll permanently delete the recording. If you want a copy of the recording, you're more than welcome to have it, and then I will retain a copy of that recording also. 90% of the time, people say to me, no, once I've agreed the notes with you, we can delete the recording. That's fine. Sometimes I get people who feel particularly aggrieved, or they have a viewpoint that things are quite contentious and they want a copy of the recording, and I haven't got an issue with that. And actually, I have to say, since I moved away from relying on handwritten notes probably a decade ago, but since I've done that, actually approving my typed transcript from a recording is very straightforward. The individual reads and goes, yeah, that's from the recording. They don't argue the point, and we all move on. That being said, if you speak to some employment lawyers, they'll go, I'm feeling a bit nervous because I don't know what your line managers are potentially going to say. And once it's said and it's on the recording, we can't unknow that. But my view is, whether you're recording or not, a line manager could, if they're not, confident dealing with those processes, they might think out loud and say something that's a bit clumsy and that's unhelpful. But once it's been said, it's been said. And if the employee's recording covertly, they've got it on their recording. And even if they're not, they're going to know it's been said. And hopefully, your note taker is going to capture that in the notes. Because if they don't, it's likely to be challenged by the employee. So for me, recording is an obvious. I think with the uprise in mobile devices and also take into consideration the development of AI and how AI is becoming much more effective at taking recordings and preparing transcripts really quickly. Seems like a no-brainer to me. But I don't dismiss concerns that if you think you've got a line manager that may say something inadvertently that's not appropriate, then yeah, you might want to take that into consideration. But then that goes back to a training piece. It's a long-winded way of saying I'm for recording, but again, if you're going to do it, make sure you're clear about it. Make sure you tell everyone that you're recording, and you don't leave yourself exposed to a complaint that you've taken a covert recording yourself.
Thanks, Nathan. We've no other questions. So I'll send out some correspondence to everyone that signed up for the event this afternoon, and I'll put a post on LinkedIn. So if you would like a copy of the slides or the recording, then please put a comment against the LinkedIn post. Our next event is on Tuesday, the 13th of May, and is called Aim High, Navigating Difficult Conversations. And a link to sign up for this will be included in the email. If anyone's recruiting, we've also got accountancy recruit, FD recruit, exec recruit, and charity recruit within the group. But otherwise, I'd just like to say a massive thanks to Nathan for your time and effort in putting the event together, and also to everybody for tuning in. Thank you.